Good morning, folks. Jeff Vastola here to give you 30 minutes of free legal advice.
On the law with your host, attorney Jeff Vastola.
That's me.
Featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
Well, good morning, everybody, and thank you so much for tuning into the radio show, and thank you, Facebook Livers, for watching. I certainly appreciate that. This is Vastola on the Law, 30 minutes of free legal advice. I'm Jeff Vastola. I'm here to give you free legal advice. All you have to do is sit back and listen. Good morning, Mom. Not wearing my contacts today, so you might see me get a little bit closer so I can read. But if you'd have a question of your own, feel free to call the show. If you're a radio show listener, the number is 877-850-8585. And I encourage you, I implore you to call the radio show with your questions. It makes the show more interesting, especially because the Facebook Livers can hear your question and can hear the interaction. If you happen to be a Facebook Liver and you have a question of your own, keep in mind, my advice is only good in the state of Florida because I'm only licensed in Florida, and Facebook Livers are interacting from lots of different states. So just keep in mind that the law in your state might be different. But please send me a question. If I can answer your question here now, that's what I will do. That's the purpose of the show. And if I cannot answer your question right here and right now, then I will do some research and I will get back to you with what I feel is an educated response to the question. You can always follow up with more questions if you want more advice, and I'm happy to do that. I'm imploring people now, I'm using a new verb, to call the radio show or to contact me during the Facebook Live feed, because what's happening with a little bit more frequency now, hi Aunt Vicky, how are you, is that people are contacting me during the week while I'm at the office working for my clients with what I consider to be radio show topics, things that I don't do during the week. So if you're wondering, all right, well, Jeff, tell us, what should we contact you about during the week? I am a personal injury lawyer. I handle personal injury claims, wrongful death claims, and I also handle medical malpractice claims. That also includes things like product liability, boating accidents, anything like that. That's what I do on behalf of my clients throughout the work week. So if you have a question about a case, any of those types of cases. I'm sorry, who was that?
Alan from Fort Lauderdale.
Oh, good. I believe this was the man that contacted me during the week. Let's put Alan on the line. Alan from Fort Lauderdale. Good morning, Alan. How are you?
Yes, good morning. Thank you for taking my call.
Absolutely.
I have a question regarding real estate. I live in a low-income tax credit property, and I want to know if there are any regulations that modulate how much rent they can increase at any given moment in time.
Yeah, there is, and Alan, I certainly appreciate you calling into the show. I had some advance notice that you were going to be asking me this question, so it's part of my show topic, and so I've done some research on it. And as I'm sure you already know, Section 8 housing or HUD housing is incredibly regulated, and how a landlord can increase rent and to what extent is also part of that regulation. So essentially, a landlord for Section 8 housing has to give the housing authority advance notice, and the tenant needs to be given a copy of that, and it's either 60 or 90 days, depending on what the housing authority may be. They have to describe what the proposed rent increase will be, and for what reason. Now, I've also found published the fair market rent values in your area. Now, Alan, if you want to give me your zip code, I can tell you what the fair market rent is currently.
33304.
All right, 33304. Okay, and do you live in a studio, 1 bedroom, 2 bedroom, 3 bedroom, or 4 bedroom?
2 bedroom.
All right, so your fair market value right now is $1,540, according to what I've found on the internet. So now to answer your question.
But so my rent is currently $10,000. It's slightly more than that, but can they raise it $500? Is that reasonable?
Well, what I found is that they have to the rentals the rental rates have to stay within the fair market value, and it can be as low as 90% of the fair market value and as high as 110% of the fair market value. Now, how high can they increase the rent from where it is now to what the proposal is? I don't know. I didn't find anything on that, but understand that they can only they're only supposed to raise the rents annually. Your lease is an annual lease typically, and they're only supposed to raise the rent at the end of the lease term. Now, there is an exception to that. There's an exception to that if something drastic should happen and the landlord is required to come up with additional funds, but it's got to be very well described and explained in their proposal as to why they're doing it. But the reason I gave you the reasonable rental rates in your zip code is because your rental rate should be around that number, and it should never be more than 110% of that number.
Well, is there something called like reasonable rent increases?
Yes.
$500 would be a big burden for me.
There's the reasonable rate increase is what I was. The reasonable rate increase is what I was talking about, where the landlord can raise your rent every year in consistency with whatever the fair market rates are at the time.
Okay.
So what's your situation, Alan? Is your situation that your landlord is trying to increase the rent by $500?
More like $300. So that's like a 30% increase for me. I think 30% is unreasonable.
Well, 30% could be unreasonable if your landlord was at 100% of the fair market rate, or even 110% of the fair market rate. But if your landlord, for example, is at 75% of the fair market rental rate and has all of a sudden become educated as to what his rents should be, then and if it's an annual rent increase, then it might be approved. Because what the housing authority is going to go by is what the fair market rental rate is in your zip code.
Well, this is a low-income tax credit property for seniors.
I understand that, and that's what I was looking at. I'm not looking at an open market fair market rental rate in your zip code. I'm looking at the public housing authority's spreadsheet for what Section 8 housing rates should be.
Now, can they raise my rent more than anybody else's? Because that's what they're trying to do.
No, they're not supposed to do that. I did read, and I know that was going to be one of your questions. They're not supposed to raise it more than other people's, extraordinarily more than other people's rents. So if that's happening, then you would want to look into issues of discrimination or something like that.
Well, they told me that because you're in Section 8, you could raise your rent more. You could charge you more money than other people. That doesn't sound legitimate to me.
No, it sounds counterintuitive. The purpose of Section 8 housing is to provide affordable housing to those that need it who are on governmental assistance. So that doesn't sound accurate to me. But if you have any other specific questions, you can feel free to send me something in the way of a notice if you've received any kind of a notice for a rent increase, and I'm happy to look at that to see if there's anything inappropriate about it. I can certainly chime in with my opinions on that, but just generically speaking, your rent increases should not be more than other folks in the same complex for a same, what'd you tell me, you had a 1-bedroom or 2-bedroom? And, look at this fair market rent spreadsheet is real easy to find. If you...
Yeah, I'm familiar with it. I'm actually getting a pretty good deal, so I'm just trying to hold on to my good deals.
Yeah, I understand that. So, but you understand too, the landlord has rights as well. And if the landlord has been undercharging you, and maybe that's the case, maybe the landlord has, you just said it yourself, you're getting a really good deal. If the landlord has been undercharging you and has just realized that, the fair market rent rate is something much higher, then that might be exactly what the landlord is trying to do. All right. Absolutely, Alan. Feel free to call me back if you think of any other questions, okay? Appreciate it. Thank you, Sharina. Appreciate the call. Good morning, Don, longtime listener. Thanks for being now a Facebook watcher. Good morning, Lee, my sister in Tennessee. How are things in Tennessee? We've been talking to Alan because this was going to be a topic of mine. Section 8 housing and how a landlord can increase the rent. And so if you were paying attention to the conversation, and Alan, I really do appreciate you calling into the show because in my opinion, it makes the show much more interesting when I'm interacting with somebody. There are certain ways a landlord can do it, and then there are certain ways that a landlord can be in violation of the Section 8 housing rules. Sorry for the bouncing around. I hit my desk, and when I do that, the iPad screen goes back and forth. Well, hey, if you live in Florida, you woke up today in Phase 3. If you didn't know it, Florida is now in Phase 3 as of last night. Governor DeSantis notified the residents of Florida that we are in Phase 3. I got so excited I went to the internet and I started reading about what's Phase 3. Well, it's not much different than what we've already been doing. The good news really is for bars, pubs, and nightclubs, restaurants, gyms, theme parks, and sporting events. Probably where you'll see the biggest difference is going to be in sporting events because unless it's a college game. I don't know if anybody saw the FSU game where all the students got jam-packed together, but all the sporting events, the auditoriums have been empty or there have been very, very, very sparse crowds. Now in Stage 3, it says large spectator sporting events should consider reducing capacity with limited social distancing protocols. Limited social distancing protocols. So I think that's probably where you're going to see the biggest difference is that sporting events are probably going to start getting jam-packed again. Now, I don't know if that's going to cause us to go back into Stage 2 or Stage 1 because, all of a sudden the coronavirus pops up again. Not to say that it's gone, but the numbers have been going down. But everything else on the list has really already been up and running, obviously, the restaurants and things. I think the biggest difference that you're going to see with regard to bars, pubs, and nightclubs and restaurants are that they no longer have to have the social distancing protocols where every other table is closed kind of a thing. It says limited social distancing in place. So I suspect that it does say that these are allowed to operate at full capacity now that we're in Stage 3. So I suspect that all of those tables with the big X on them with tape will be taken up and, restaurants are going to be more full. And we hope. Gyms, they should be open to full capacity. I don't know about your gym, but the gym that I go to infrequently, there was nothing really in place as far as closing down equipment and stuff like that. It was, now my gym is never really crowded anyway, but I don't think I'm going to see much of a difference. Theme parks may return to normal operations with limited social distancing protocols. Every single one of these paragraphs says limited social distancing protocols, but it doesn't go on to define that. Now, it may be defined somewhere and I just haven't found it, but I don't know if they're going to be, tearing up that tape on the ground that says every 6 feet, or alternatively, if they're going to leave it there saying, hey, we think this is still a good idea. Let's try to keep people spaced apart. That would be my take on it, I think. Probably try to keep your distance when possible from everybody else because, of course, the virus is still here. It has not gone away, but if you're just waking up in Florida, welcome to Phase 3.
Ron
Life
from
is
West Palm
different.
Beach.
I'm sorry, Sharina, did you say Ron?
Yes, Ron from West Palm Beach.
All right, let's put Ron on the phone. Ron from West Palm Beach. Good morning, Ron. How are you?
Very well, thank you. How are you doing today?
I'm doing just great. I detect an accent. Where are you from, Ron?
Originally, I'm from the great state of England.
All right. What part?
Well, we can argue that at the moment, but so I have a twofold question. Obviously, I'm not going to name make any claims and
Yes.
state the name of this facility. But
I appreciate that.
I've had a self-storage facility I've rented out for about 10 or 11 years now, the same space. I'm actually calling on behalf of a friend of mine. So 2 weeks ago, they resealed and repaid the facility where they had parking spaces that they rented out to people that run businesses, So my friend in question has a moving business. So he had the same space for 5 years, and naturally the rent's up periodically, no big deal. So recently they kicked everybody out for about 3 or 4 days so they could clear the parking lot and reseal and repave everything. So, and then what they did, they restriped the boundaries, you know. So in other words, what was once, say, a 12 by 12 space to put in a box truck is now less. Yep. So what they did was his rent was something like $180 a month for the space, right? But when they redid the boundaries, his truck didn't fit in the new boundaries. So they moved into a different boundary and raised his rent by over $50. So can you do that?
Well, the first place I would go is the lease agreement, because the lease agreement will set forth the rights and responsibilities of the parties. And then if the answer is not patently obvious within the lease agreement, the next place I would go is Florida Statute 83. Florida Statute 83, I'm going to cough, apologize, regulates storage relationships in the state of Florida. So if you haven't already gone there, tell your friend to go to Florida Statute 83. There are 3 sections: residential tenancies, commercial tenancies, and storage units. And it's a real easy read. Florida Statute 83 is written in easy to read, easy to apply format. And if your answer cannot be found in either the lease agreement or utilizing the statute, or if after reading those things you say, you know what, this really does require more of a legal determination, then, you know, call me back or have your friend contact me. I'm always happy to take a peek at a written agreement to tell you my thoughts on it. And if necessary, I can take a look at the statute. What's that?
Is this your field, your speciality, these kind of agreements?
Well, it used to be. I did a lot of commercial litigation when I was a younger lawyer. I've streamlined my business now to be personal injury and wrongful death claims, but I'm still very adept at looking at commercial lease agreements and things like that. Obviously, what you can tell is that the company had a space planner come in and say, whoa, you know, if you change things up a little bit, you know, you could probably make thousands more every month. So that's very likely what happened. But whether they can, you know, just whimsically increase your friend's rent, I'm not so sure. That would depend on what's stated in the lease or the statute.
Yeah, well, it seems a bit suspect, though, that, you know, you're in the same space, no problem, and it has a specific boundary and a specific size, but then, you know, all of a sudden they rezone, so to speak, all the boundaries and reduce the amount of space so they can get more cars in, you know, and I'll create more driving space around the building, and they suddenly move you to a different space that costs more because you don't fit in the old boundary. But what they did also, you see, they had him sign a new lease, and I said to him, did you sign it? He said, yeah. I said, well, you know, I don't know now if the old lease, obviously the old lease doesn't apply anymore because he signed a new lease into a new space.
Yeah, well, then that's probably the answer to the question. If he signed the new lease for the new space, knowing what the size limitations were, and, you know, if none of the terms were in any way deceptive, then I think it's a foregone conclusion that he's going to be stuck with the new rent.
Yeah, but it seems like they coerced him into the new lease without him realising, because, you know, this guy's just a nice guy, you know, and he just kind of, you know, the kind of person that would just sign anything without me. I know he's not supposed to do that, but, you know, it's my opinion that they just coerced him into signing this to get out of any litigation, for realising that the old boundary, the new boundary wouldn't fit. His truck wouldn't fit in the new boundary, so let's move into another one. I mean, I understand, you know, a $15, $20 raise in rent per month, but $50, $60 per month, because he has to be in a double space now to accommodate his truck, whereas before he was in a single space. I
understand that, and that's all about the space planner coming in and explaining how much more money they can make by just moving the lines over a little bit. Good morning, Maura. But I think the new lease is really going to be the death knell to any claims. But if there's anything specific about the interactions, if you want to have your friend contact me, I'm happy to talk to him to see if maybe he was deceived into signing a new lease. I don't want to get his hopes up, but it's something we can certainly talk about.
Yeah. And that statute was Florida Statute 83, correct?
Correct.
Yeah. Okay, now one last quick question. I know I don't want to take up too much time, but I've rented out for 10, 11 years now. I've gone through 3 or 4 different managers, never had a problem. And I run a small business out of it, a little contracting business. So recently, the new manager, I had I'm going to say an altercation with his district manager. Not an altercation, a disagreement. And so anyway, I'm kind of like, a marked man in this particular facility. So the other day, I was here for 2 or 3 hours, and then I was told by the manager that I'm loitering on the premises, and I have to leave. He gave me 15 minutes to leave for loitering. I said, well, I have a signed agreement with you. I'm in my own state, my own territory, I'm paid up to date, so how can I be loitering? And he said, to terms, I have discretionary powers to make basically to make his own mind up as to what the rules are.
I find that hard to believe. So I don't think you're going to find that in the lease. So I would, again, it's a matter of go to the lease first, see what's written. Sometimes these places do have some restrictions on, I don't know. I think I'd be stretching to say that there's restrictions as to how long you can spend on the premises. But it might suggest that, if you're going to be on the premises, you have to stay to your little unit. And if you happen to be wandering all over the lot, going to other units and things, that could be stretched into a loitering or a trespass, something like that. But obviously...
Yeah, for that I don't. I'm specifically in my own little spot. I never go, except I put some garbage out sometimes. Other than that, I'm in and I'm out. I know that there are certain hours that you're allowed on the facility. I understand that, but beyond those hours, within the confines of those hours, you're legally allowed to be here according to the terms of the contract. But what I'll do is I'll get my contract out, I'll read it. If there's any problems, I'll give you a call. And I was actually thinking about some litigation about this company because there's some other issues as well, but I'm not going to discuss.
All right. Well, think long and hard before you jump into litigation, especially right now, because litigation is never fun. But there's essentially a freeze on litigation. That's actually one of the things I was going to be talking about when it comes to landlords and evictions. It's another question that I have to get to before the end of my show in 6 minutes. So let me let you go. Feel free to call back next week if you have any follow-up questions, okay?
Okay, thank you very much.
All right. Thanks for calling in. I appreciate it. Good morning, Lindsay. How are you?
Wilbert and Lakeworth.
Wilbert, that's my other question. Okay, let's put Wilbert on the line. And Wilbert, are you with us? Wilbert, can you hear me? Hello, Wilbert. Yeah, Wilbert called me during the week. I'm not sure if he can hear me or if he's got a decent connection, but he wanted to know about landlord evictions in Florida. Again, I'm only talking about the law in Florida. I know people are watching from other states, but right now, until October 1st, Governor DeSantis extended the moratorium on evictions, landlord-tenant evictions in the state of Florida. And also the CDC implemented a moratorium on evictions as well. For any entities that get CARES Act money, they are not allowed to evict. So here's the deal. As a landlord, if you have a tenant that's not paying rent, there are some defenses in play now where a tenant can say that they haven't been able to pay rent because of the coronavirus. Now, they're going to have to back that up and prove it. But essentially what you can do is you can file a lawsuit for eviction. And again, pursuant to Florida Statute 83, as I just mentioned a few moments ago. But the courts are prohibited from actually entering an eviction order until October 1st. I suspect that might get extended. Now, I don't know for sure, but Governor DeSantis has already extended that at least once through October 1st. So the moratorium does not say that you can't file the lawsuit for eviction. But what's happening is the landlords are filing these lawsuits for evictions, and it's jamming up the court system. Now, as we all know, our court system was already pretty jammed up to begin with. But what's going to happen is once the moratorium has ended and the courts are now allowed to enter rulings on evictions, the court is going to have to take these cases one by one, bring the parties in, listen to the tenant, and find out, does the tenant have a justifiable excuse for not paying the rent? Because, as I mentioned, there are now defenses in play because of the coronavirus. For example, if somebody lost their job, they were terminated because of the virus, or if they caught the virus and got sick, these are all things that are going to be used by tenants to say, this is why, Judge, I wasn't able to pay the rent. And specifically, if you receive any form of federal funding through the CARES Act as a landlord, and there have been some provisions for landlords, specifically commercial landlords, to receive CARES Act funding, then you are prohibited from evicting your tenant until these moratoriums go away. So, and perhaps even beyond that, if you've received funding from the CARES Act. So, if you have any questions as a landlord about, what truly are my rights, feel free to call in or email me, type into the thread if you want, and I'll try to respond to questions specifically with more specific answers. But that's essentially the answer to the question. Wilbur, who was supposed to be on the line, I don't know. Are you there, Wilbur?
No, he hung up.
He hung up? Okay. Yeah, he was a person that had contacted me during the week. And so I had asked him to call during the show and we would get to his issue. But that was the question that he brought up that I wanted to mention. So I'm glad that I was able to get through all of my questions from people that contacted me during the week. I've only got about 30 seconds left. Remember, if you'd like to talk to me about a case, personal injury, a wrongful death claim, a medical malpractice, product liability, boating, whatever the case may be, call me at 833-VASTOLA. That's 833-827-8652, and I will be happy to talk to you 24/7, and just let me know how I can help you. Have a great weekend. God bless. Bye-bye.